Ladies and gentlemen, let's get down to work. I will talk in Russian, so will most of the panelists. However, part of our panelists are English speaking, so if you struggle with English, please take care and make sure that you've got simultaneous interpretation headsets with you. So this session is called In One's Own Right. And the topic of the session is how to implement the rights of internet users, service providers and regulators in a technologically complex environment like the internet. Let's hope for a comprehensive and useful and constructive discussion. We have really star panelists represented here. I'd like to introduce them. Damir Gainutdinov represents the very well-known human rights association Agora. Roelof Meijer represents SIDN, the CCTLD. Roelof, what's your family name, please? Tell us tell the anchor.
Roelof, но по имени, как мы обычно называем в нашем интернете.
Okay, thank you. Alex Pawlik is our next panelist. He has already talked today. He represents RIGF NCC and is responsible for addressing in our region. The next panelist is Pavel Rassudov, who represents Russia's Pirates Party. A great party with a great name, at least, and great assets. And I do understand that such a party will not mince its words. Alexander Shepilov is one of the best experts in internet regulation in the upper house of the Russian parliament, in the Federation Council. And Madina Kasenova, who represents the Diplomatic Academy of the Russian Foreign Service, and he is one of the best experts of the Russian Foreign Ministry on international regulation of internet rights. First of all, I'd like to ask each of our panelists to tell us what, according to their professional experience, should all the entire community do in order to make sure the rights of all stakeholders on the internet are honored and respected. The internet is a technologically complex solution. Hundreds of millions, billions of people across the world use it. In Russia alone, tens of millions of people. And as any technological system, one needs to, first of all, protect the rights of consumers. According to Russian laws, there is always a presumption that consumers, users, and owners of private data have certain rights, and the regulator, who represents the government, and therefore has a right to draft laws and adopt their own regulations, have responsibilities. They don't have rights. The operator of private data, according to the Russian law, doesn't have rights, but they have responsibilities and obligations. Do you think that this point of view, very workable for physical systems, applies to the internet? What are the pros and what are the cons? So if you could be as brief as possible, but at the same time as comprehensive as possible on this topic, you're welcome. So the only aspect that I will need to hear from you is just this opposition: rights of consumers against the responsibilities of regulators. Okay, Damir, you have the first floor. Thank you. I'd like to start with reminding you one of the key provisions of Article 1 of the Russian Constitution. The Russian Constitution says that the rights and freedoms of men are the highest value. So this is exactly how I think we should approach this issue. And it is from this premise that I think we need to look for the balancing act between the rights of various stakeholders. From my professional experience, I can tell you that unfortunately we have almost killed the system of protecting the rights of consumers on the internet. Agora has been monitoring internet freedom in Russia for at least 18 months. And in the meantime, we have registered at least 150 various draft proposals from state officials. Not a single of those proposals was aimed to guarantee or secure the rights of consumers to get information, to disseminate information, to act freely in the online world. So all of them were of restrictive nature, introducing criminal or administrative liability, blocking websites, creating stop lists, and so on and so forth. Some extrajudicial ways to block unwanted and disloyal websites have been used by the government. So I think the point of view from which we look at this problem is how to save rights of men on the internet. All right, what's the situation in the Netherlands? The Netherlands have more domain names registered than Russia in their CCTLD, even though the Netherlands is a little bit smaller country than Russia. So what can you say about how you secure the rights of people who use those domain names?
To your final question on the model, I think in theory the model should work because a state is there to protect the interest of its people, and I think a regulator is an instrument that can be used by the state to do exactly that, protect the interest and protect the rights of its people. I think often where it goes wrong is if a state or a government starts to protect something that is felt as the right of the state or the right of the government. And then you get very often a conflict between what the regulator thinks it should regulate and what the interests of the people are. And I'm sure that also in the Netherlands we sometimes have this tension between the interests of our government or the interest of the state and the interest of its individual civilians and organizations. The way SIDN tends to balance its policy on the interests and the rights of its different stakeholders by organizing domain debates that we use to formulate our policies. But of course the registry is not really into the content which is on the websites that are based on the .nl domains. And I think often there is the real discussion about interests of different parties. And we have, I think globally, we have a tendency to refer, for instance, to the rights of individuals as they are stated in the Universal Declaration of Human Rights. But since we have a colleague here on the panel of the Pirate Party, maybe it's also another thing that is also in the Universal Declaration is the rights of people who on their intellectual property, and I think there's also very often a tension between the interests of different groups.
Спасибо, но я в этой связи хотел.
Thank you for that. What I'd like to point out is that there is an alternative viewpoint. The government, according to this viewpoint, the government not only protects the freedom rights of the consumers of the internet services, but it's got also to protect the public interest, the public decency, by protecting the users of the internet from inappropriate information, thereby contributing to and facilitating the sustainable development of the internet. This is exactly the question that I'd like to put to RIPE NCC. So what can Axel Pawlik tell us about this counter-opposition?
Now, I would like to go back to the fundamental principles. I think what we all have to remember is that transparency, openness, and inclusiveness is at the core of all this. And when I remember the situation 15 years ago, roughly, or 13 years ago, when the World Summit on the Information Society was arriving on the horizon, we were all very much in panic. We are the technicians, right, the technologists, said, oh my God, now the governments are coming. They don't understand what we are doing. How can we solve the world, or no, rescue the world, solve the situation here? And I think what we in the RIPE community do is we reach out and we, similar to what Roelof said, we facilitate debate and understanding, mutual understanding as much as possible. And certainly over the last 15 years, what we have learned is that it's not just the technologists or maybe the end users of the internet that count, but also, as you say, the governments and that aspect of daily life. And that is something that we believe very strongly in. And hey, it's the Russian Internet Governance Forum with a very mixed populace. You have very many different attendees from all sorts of life, all walks of life, and we have people on the podium also from governmentally associated institutions. So that's something that I strongly believe in: debate, balance, and not just one very small view from one end of the pie. Thank you.
Спасибо, Алекс.
Thanks, Alex. I'd like to ask Pavel Rassudov the same question and an additional question. Pavel, well, the name of your political party is, well, let's face it, is a real negative word in the Russian language, maybe in others. Isn't it sort of a roadblock for you, or a... Well, no, it isn't. The original meaning of the word is pirate as a searcher for something new and soldier of fortune. Well, in fact, let's face it again, all seamen were pirates when there were uncharted waters, and they went. It is they who went to uncharted waters. So the internet, the people who created the internet, the people who went into the uncharted digital waters, they were also pirates. Of course, a lot of people refer as pirates only to people who infringe on the intellectual rights and copyrights. However, we think that using intellectual property for personal purposes without any commercial benefit is as an inalienable right as any other rights. So it is the first right of any user of the internet is the right to access the internet. The internet is a public good, created for the public good. And we don't want access to a couple of copper wires. We want access to the information that the internet brings to our households. In an information society, access to information is a basic psychological and physiological need of a human being. It is the same as the need to have sleep, the need to have sex, the need to have security. And when we are deprived of information, information hypoxia is almost as horrible as well, oxygen hypoxia, because your brain contracts and your brain cells cease to work. The second inalienable right connected to the internet is the right for digital privacy. And the implementation of this right, of course, is internet anonymity. The value of anonymity is not just the fact that people can create a lot of personas, but it is also an opportunity to lie with impunity. I say lie in inverted commas, that when I want to say that people must be able to disseminate information, truthful information that cannot be legally proven, but still it is disseminated for the public good. I see that you don't understand what I'm saying. For instance, information that Edward Snowden, Julian Assange and other people have disseminated, it was classified as defamation at a certain point. If you have any questions about this, I will be happy to entertain them. And yet another inalienable right, which is infringed upon in Russia in a very horrible way, because I think Russia is a country of total internet censorship at this point, is a total and unrestricted freedom of speech. Because in a postmodern world, if people tell you, go and climb trees, this is the same as go and climb trees. So, kill yourself by biting yourself against the wall, right? This is what people say. It is the equivalent of the English go and climb trees, right? So, if you use this phrase, technically, you might be legally sued for calling upon people to kill themselves. You sort of instigate suicides, right? So I think when we talk about liability, when we talk about censorship, we need to be very reasonable and rational, especially when things like hate speech, aggressive speech, and offensive speech is concerned. Because people must be polite in the street as well as on the internet. However, when people are impolite on the street, they are punished administratively, and when people are impolite, including defamation on the internet, they are supposed to be punished criminally for that. So these four inalienable rights, I think, should be treated as inalienable. The right to access any information, the right to use intellectual property for personal purposes, right for privacy, and right for the freedom of speech are the most important things to be put on the table these days. Okay, thank you. Thank you. Alexander, as someone who can be called a lawmaker, can you tell me whether you take account of the psychological and physiological need of man in your professional activity? Well, we do. We do, but at the same time, we suggest that a human being is a social and political animal, and therefore human needs should not only be physiological, but also social. And we have to take into account that as well. I have several points to make. Number one, and a pretty philosophical one, I admit. The Russian version of this section is called In My Own Right, and the English, official English name says Injustice for All. Justice is if you translate that into Russian, justice doesn't look like legal right, but it looks like fairness. So, to the Western European civilization, these two are more or less the same. to a member of the Russian civilization and cultural tradition, they're not the same. So when we talk about equality or inequality on the internet, we need to talk about justice as fairness, not justice as a procedure, right? So justice is not something that you can translate just straight word by word. Now I will pass on to my points. Damir said that at least 150 draft laws were considered, and not a single of them protected the rights of men, and all of them wanted to restrict the personal rights on the internet. But we have seen the statistics earlier today, and no one has spoken against that statistics. .ru is in 6th place in the world in terms of the number of domain names. I don't understand how this could be possible if the situation was as horrible as this. If we restricted the rights, if we restricted the freedom, if there was total censorship, if people could not develop their business on the internet, I'm sorry, but I don't understand how we could make it to 6th place in the world, this domain being preliminarily Cyrillic. So, I don't understand. My second question is again to Agora representative, whether he is aware about our two latest initiatives. Amendments to the law on private data, Federal Law 152, and our amendments, second package of amendments to the law against mobile spam. So if you know about them, could you tell me whether you think these are restrictive or protective initiatives? Because actually we see it as restricting people who provide services on the internet rather than the users of the internet. And of course, you need also to look very closely at those 150 initiatives. How many of them have passed into law? You will see that a big minority passed into law. Lawmakers these days have suddenly awakened to the need to regulate the internet. If you look at what happens in Western Europe and North America, you will see absolutely the same picture. The European countries and the United States have adopted all those acts that Russia is still only considering several years ago. Our colleague from the Pirates Party told us that the intellectual property must be circulating freely. You say that there is no such thing as intellectual property, but what about the motivation of people who are supposed to create intellectual property? Well, I think their motivation should be humanitarian, and historically all creativity was humanitarian. Because if you create an intellectual product just to sell it, the best recommendation is not to hear this music, is not to look at those pictures and not read those books. So they are businessmen and swindlers, not creators. Well, these words sound really smart, but without the commercial interest, we wouldn't have Apple, we wouldn't have Google, and we wouldn't have Microsoft. Because this is a workable mechanism, and we need to protect this mechanism. And Mikhail, in his introductory speech, said that the internet is a technologically complex system. However, my point is that we don't need to look at it as a technological system. It is a system of relationships. So, what the government has to address, and what lawmakers have to address, is that the technological capabilities that the internet brought to people are already a commodity that has already changed people. And we have to form our behavior in accordance with those changes. The internet has not changed basic human rights, but it has changed the implementation of those rights. And this is exactly what has become complex. For instance, Damir has said that extrajudicial ways to block websites have been used. But now let us talk to copyright holders. When I talk to people who have invested in movies or in music, they tell me the following. Even before the first night, we see our movies on the internet. However, this wave subsides after the first few days. After all the people who want a pirated copy downloaded it, no one actually is very much interested in pirating it again. However, this means that the copyright holders have already lost a lot of money. And for example, if in a couple of weeks after the first infringement, the court finally makes a decision, this court decision is not going to make any difference because no one is going to compensate copyright holders for the losses. I'm talking about this only to give you an example that the internet is much faster and requires much faster response than the traditional legal mechanisms and legal entities. So we've got to look for a new balancing act between bureaucracy and procedure and the need to act fast. For example, again, corporations like Microsoft and Google and Apple are most technologically advanced entities in the world. They own a lot of, well, they don't own, they control a lot of private data, and that makes them as influential as governments. And I think, you know, governments lost this paradigm at some point. At first, they thought that the internet is a great and smart toy, and only when they awoke to the fact that the internet has changed people a lot and they have lost control of that change, they are currently trying to catch up. Not just the Russian government, I repeat, the United States government, for instance, as well. Well, Madina, what can you, from your legal standpoint, say about what we have discussed so far? Well, it's hard for me to add any specific points, but what I'd like to do is to underline certain points very subtly, because we legal people are very boring people, and we cannot say, for instance, that Alexander is actually changing the paradigm and shifting the paradigm. Protecting the copyright holders and protecting the right to access information are two different things. Antithetic things, I would say. I have two basic points to make. Number one, we must not distinguish between online human rights and offline human rights. Human rights are a comprehensive notion, and it doesn't absolutely have any meaning how exactly they are implemented through the telephone, through the internet, or whatever. At some point, telephone was written with a capital T. At some point, the internet was written with a capital I. Right now, we have decapitalized them just because they have become a normal context of life. And this just means that we need to protect the rights of people in the same way as offline. And if we say, and here is where the Pirates Party position comes in, if we say that Human rights are a comprehensive notion and should not be distinguished between online and offline because it splits the unity of one of the basic legal positions. My legal opinion is that the internet is over 45 years old, technically. And throughout all these years, the internet has developed as a multi-stakeholder system. So this multi-stakeholder model has already grown, has already developed, and proven its effectiveness. Governments have stepped in only in the past 10 years. And from this point of view, Alexander is right. For any government, it is an uphill battle to catch up when a product or a resource is already about 30 years old. However, this overzeal of the government must be compensated by universal rights. And if the government does not restrict its own strength and its own power to curb primary rights to access information, to have privacy on the internet, then we cannot say that this government upholds the rule of law. I also agree with a colleague from a Pirates Party that a right to access the internet must be treated as an inalienable right. But right now, we live in an environment when this is regulated on a national level and therefore differently. In Finland, in Estonia, and in France, access to the internet is articulated in the law. Finland is, I think, the first country in the world that introduced the right to access the internet in its constitution, which automatically makes it an inalienable right. In some other countries, access to the internet is seen in the context of another inalienable right, the freedom of expression. Here, from the legal standpoint again, the situation is a little bit more dubious, because some people must be too careless when they interpret these rights rather than articulate them. All right, thank you. Thanks, colleagues. Well, the panelists have implemented their right to express themselves, and now they will have only the responsibilities to listen to your questions and answer your questions. Before we progress to questions, I would just like to ask you to ask our online questions first. And before we do that, I will tell you one thing that I always say to my students when I read lectures on the regulation of the internet. The issues that we are putting on the table here require a very clear understanding that whenever we say rights on the internet, online rights, and so on and so forth. However, in reality, the internet is not a united system. When we talk about the internet, we mean a network or a technological system. And if you have a technical background, I think you remember the 7-tier model of any open system. And therefore, when we talk about regulation, we need to talk about regulation at a certain level. On a technological level, we have regulation, operators, internet exchanges, traffic, and so on and so forth. The next level is the level of access different rights and different subjects of those access. Then the regulation of addressing and domain spaces. Here we have people from organizations who are responsible for this. And here we have different rights and different responsibilities. And at upper levels, we have the regulation of the content of the internet. Quite a different regulatory environment, different rights and responsibilities. So at least 4 levels we have on the internet, and of course we just cannot have a single approach to regulate all these 4 levels. So when people just talk about rights on the internet, I don't think they do understand what they're talking about. So in order to find a common language, we need to actually see what our common denominator is. So have we got any questions from the online part of our audience? Yes, we have a question from user called Irina. When you honor human rights on the internet, you automatically honor the same rights on the internet for software agents as well as human beings. So they are not. So if you watch the movie Tron, then I think you can answer this question. Or Matrix. Okay, you haven't watched this movie, so maybe you don't know who these entities are. Well, according to the theory of law, the only subject of law is a human being, a being with a will. So if we say that, for example, our cats and dogs and pets don't have a will, they don't have rights, including on the internet. So maybe this is not a correct question. So please ask your questions using a microphone and identifying yourself. Good afternoon. I'm Andrei Gordilov. I'd like to pick up on what Pavel Rassudov from the Pirates Party said. In the olden times, in peasant Russia, in a peasant community, you had to sort of deserve a right to speak in a public gathering. On the internet, anyone has a right to speak anonymously without actually proving first that you deserve the right to speak. Another problem on the internet is that anonymously you can technologically and physically create a community and influence that community without taking responsibility for what you say. Do you have practices to find out these, well, let's call them troublemakers or people who engage in this misbehavior and curb their activities for the public interest? Well, I've quite recently come back from Thailand, and they've been in a revolutionary environment for several months, and they want to curb the educational rights for part of their citizens. Southerners in Thailand are generally more educated, northerners less educated, they're growing rice and all that, and southerners say that we have to curb the rights of those northerners to elect officials. So when you say lie or defamation, whenever people say, well, people, if they say something, they must be people, right? Even though they use only their nickname. You have to treat them on a fair basis. Giordano Bruno, as you know, voiced opinions that were absolutely antithetic to what Church said in ancient Italy. So, of course, the Russian Orthodox Church will not burn us alive these days, but when you say that someone doesn't have a right to say certain things, well, in discussion, in a fair discussion, truth always prevails. So I don't think that this is a fair point that you're making. Mikhail, can I pick up on what you said? On the internet, as far as I know and as far as I have seen, truth does not always prevail. On web forums, on Twitter, well, does not always prevail, what does that mean? What does that mean? Well, I haven't interrupted you, Pavel. I think our colleague has put on the table a very important question, and you have ducked that question, because no one actually understands what to do with this. For example, someone has published untruthful information about another individual or about a company. Thanks to the specific points of the internet, hundreds, thousands of people can simultaneously see this information, read this information, and correct their behavior on the basis of that information. Okay, someone says the central bank has revoked the license of this or that bank. People will rush on that bank, but when they find out suddenly that this information was not true, that organization will already be bankrupt. Well, you made a great example. And people from the banking sector, they actually complain that they cannot get sufficient feedback. I'm not saying about any sufficient feedback. Well, you think that this is a lie. Why do you think that this is a lie? I'm not talking about this. I'm saying that the situation has changed compared to offline world. So if you have published a knowingly untruthful information in a newspaper, that's one thing. If you had done the same on the internet, that's quite a different thing. Well, this is exactly what I'm asking you to do, to prove that someone has infringed on your rights and incurred some damage. For example, I call you an idiot, right? I have not incurred any damage. Oh, okay, not idiot. I will call you an untruthful person. Well, that's already defamation. Okay, prove to me that you have incurred some damage. Okay, if you call me an untruthful person, according to your logic, I must prove in court that I'm a truthful person? No, you must prove that there has been some damage incurred upon you. If you prove that, then we will have a subject for discussion. And if there is no damage, there is no subject for discussion. Okay, thank you for that discussion. Let us have some more questions, and maybe we will have some more of that later. All right. Thank you for great presentations. In fact, well, I will try to be brief, but I have to start with a comment. When you listen to Pavel, you understand that there is something in his words, because all people have a right to access information and to process information. And in the beginning of our conference, so anyone has a right to get as much information as they want. On the other hand, Alexander is always right. And I represent Russia TV channel, one of the biggest copyright holders. On the one hand, I do agree that people who sort of create intellectual property in order just to sell it, they are not artists. Of course, they are businessmen. But for instance, when a computer programmer is writing a novel in his free time, maybe they don't want to sell it. Maybe they don't want to sell it, but much of the intellectual property that is being created must invest a lot of money to make sure that their intellectual property find its way to the consumer. So my question is, so you've got to invest, and when copyright holders lose money, they lose any interest in creating something down the road. And that means that in the long term, it infringes on the rights of people who consume information. So let's talk about it in a correct way. Copyright holders don't create anything. Authors create anyone. Authors create things. All right. This is a big discussion, so let us progress to my question. We need to uphold people's freedoms, but at the same time, we need to impose limitations Alexander talked about. Repressive measures don't work, but that just means that we need to be much more creative in thinking of things to sort of have a balancing act. We have a lot of people here who have done a lot and who have made a lot of achievements in this area. So any of you has a brief response? Okay, Alexander, you were first. Well, I'd like to ask our European colleagues to tell us how much money infringers pay in Europe for infringing on intellectual rights. I can tell you hundreds of thousands of euros. Is it repressive or not? I have also a brief proposal to our government. I have a very patriotic proposal to infringe or to limit the rights of American copyright holders in the Russian Federation as a sanction against American sanctions against Crimea. Okay, can I ask our colleagues from the Netherlands? You look bewildered by the information. You sort of you're struggling. Are you struggling with the amount of information or with the content of the information?
On us to solve this problem, but like I said in my opening remark, if you look at the Universal Declaration of Human Rights, there is a chapter about rights to freedom of speech and the access to information, and there is another chapter that is about the rights material, for instance, rights that an author has over whatever he created. And I think we have to be careful with taking one chapter of that declaration literally and very broadly, and take another chapter and then we don't like it so much and we make it much narrower so that it fits what we want to obtain. And I think that's the wrong approach. I think one of the remarks we got from the public that it is so easy, for instance, to defame somebody on the internet because you put a message and thousands of people will read it and will take it for true. I think that will change over time because what I see already in the generation after me, that young people don't take everything that they read and find on the internet for granted. They know that there's a lot of rubbish floating around, and they have their ways in which they select what they believe and what they don't, and have their ways, and that's even more important, I think, to find what is true and what is not. I heard in this morning opening statements, I think it was also somebody from your government, he referred to newspapers and books. They contain truth, and the internet is just a pile of rubbish. I think that's it's not a correct conclusion. I know that even in my country, newspapers contain a lot of rubbish. And there are also countries where you shouldn't take newspapers literally because a lot of information is not there. So I don't think that in that sense the internet is completely different from everything that we've been used to. It's larger, it's much easier to get a message to a lot of people, but more and more we will become aware of that and we'll be able to treat that particular information in a way that we should.
Спасибо. Alex.
Thank you. Just to go back to the question a little bit before and basically about untruth and similar lies on the internet. As we all have heard before, I'm sure the internet tends to route around rubbish. And I have a very nice example in my head currently of somebody contributing to a mailing list that is increasingly being ignored because obviously it's rubbish that is contributing. Another thing I want to mention is that after so many years, the internet is changing the world and has changed the world already. And I do have a certain amount of sympathy for the Pirate Party's view in terms of accessibility of information and intellectual property. On the other hand, I do very much support artists and authors, and I would like the creative world to continue to make movies that I like. And I think at some point it is also a matter of changing the business model. And I think we all have been very annoyed by DVDs. Remember DVDs, those round shiny things that have a region code on them? That is such a stupid idea. And I think it's going away over the last couple of years to some degree. And there are ways to finance artistic expression and give people, artists, some dollars to live off using the right way. And that's not by overcharging and selling a piece of software for thousands of dollars or euros or Deutschmarks, whatever. That doesn't work so well anymore, and prices have come down, and people have adopted those business models.
Спасибо. Павел, Мадина, давайте мы выслушаем еще вопросы, чтобы иметь возможность ответить.
Madina, I think we'll need to listen to more questions. Please identify yourself. Oleg Kulistikov, SRP. When we talk about privacy on the internet and government regulation, some people from the internet community, they dodge the very important question. When they say that privacy is imperfect, they say, well, privacy is imperfect because people are not adequately protected from the government. And the internet community's suggestions, they are always again directed against the capacity of the government to regulate internet and to police internet. They are not pro-private users, they are anti-government, which is a different thing. On the other hand, de facto, the internet has provided impunity to a lot of people who know how to use the internet, but that doesn't give them rights. For example, domain registrars don't have to identify a person officially who owns the domain. Almost all the domains that have been blocked according to a court order don't have stated owners. Almost always. Because if you look at their ownership information, you don't find any ownership information. So is this infringement of rights or not? Well, I have a comment to pick up on that comment. Actually, I don't see any problem here, but I do agree with your approach. If we look at real life, in real life, government always has an opportunity to identify a person. A government official who is responsible for doing so demands that the person produces an identification document. And a person cannot socially interact without an identification document. I think the internet has matured to a point when a similar mechanism is needed. Of course, it is not always so that a government cannot identify a person who has done this or that on the internet. However, so far, this is prohibitively expensive. And the fact that the internet is a transborder system means that a crime against a Russian citizen or against Russian interests may have been committed by a person who is physically present and who is a subject of a different jurisdiction, British Virgin Islands or China or whatever. You have to carry a passport, right? But are you anonymous at the same time? I think yes. So on the internet, we need a mechanism that is similar. Everyone should carry a passport, an internet passport with them, and whenever there is a legal demand to produce that passport, people need to produce the passport. Well, I do have a very, very definite answer to that. I represent the newspaper Moskovskaya Pravda. I've maintained my personal website since 2002, and it's been several times closed down for alleged extremism. Those accounts that actually misbehave, they are very easy to identify. And you can block an account from accessing your own resource. However, there is a big problem with illegal advertisements. There is a problem with ISPs who are afraid of everything, and they close you down at the first suspicion. I have managed to prove my innocence to my ISPs, but I actually support the pirate party, and I carry copyleft sign on my website, which means that I do not wipe out any content from my URL, even if some people complain about the infringement. So I think the biggest point in whether there is a political will of the government to close down the internet or open up. Back in 2008, there was the government will to close down the internet. It subsided. I don't know the reason why, but it subsided in 2009, and since then bloggers became as influential as journalists. And people who maintain web resources, they are not stupid people, and if they have an interest to protect themselves against troublemakers, they can do that without even blocking people. However, it's a big important problem for me to protect against unlawful blocking of my resource, because people just allege that I'm an extremist. They have not proven it, and I have to prove that I'm not. Well, I will have to disappoint you. In the current environment, it is absolutely impossible to protect yourself. 98% of cases that are currently being heard, 98% of cases end in a blockage of a website. So there is absolutely no competitiveness in the judicial process. I see two big problems there. First of all, the draft laws and even laws are written so badly and are written by absolute non-professionals. Even judges, even courts don't understand them. If you take the political censorship law, people who have to implement those laws don't understand the text. This is the first problem. And the next problem is that the government authorities don't honor even those laws that they have themselves written. The Black Thursday, the 13th of January, when several media had their websites blocked down, has demonstrated that even those draconian laws are not upheld, because the General Prosecutor's Office and the Russian Telecommunications Inspectorate say openly that they will not provide information why this or that content has been blocked. So I think that these people from the prosecutor's office or from the inspectorate, they are cleverer than us, they are smarter than us, because they can read that information, but they don't allow anyone else to read it. Well, this is why they sit on the State Duma, I think. Sarkis Darbinyan, attorney of Roskom Svoboda, so Russian Committee for Freedom project. Well, I'd like to bring our discussion a little bit closer to earth. I could talk about many cases. I'd like to ask two questions, one to Alexander, one to Damir. Alexander, you are a proponent of the anti-piracy law, and you said that it would be normal to block a website for infringing rights for a video film. When this law was adopted, it was presumed that it applies only to audio and video products. Of course, a lot of copyright holders associations wanted to expand the scope of the law, because, again, we cannot use laws selectively, protecting some people and don't protecting others. However, there are a lot of cases of so-called copyright rackets. One of the photographers sued Izvestia, a very well-known daily, saying that they had used his photos without his permission. So, don't you think that if all your drafts are voted into law, don't you think that we will be overwhelmed with lawsuits? Because anyone who has reposted a photograph on Twitter will be treated as a violator, as a trespasser of other people's rights. So do you think there are some rights that have to be protected and they ought not to be protected? Well, there is a problem there. That's right. And even when the scope of the draft law was very limited and it was limited to video products, that problem was already there, which was absolutely understood by all people who discussed it. If you take any kind of content which has an author, therefore an author has certain rights about this content, and they can technically sue everyone. And this is why I don't have a clear-cut answer to your question. I think we've got to make a very, very fine balancing act here. It is a very fine line between total protection of rights ownership and protection of the rights of people who post content on the internet without maybe even knowing that it's not theirs. Another thing, a very similar thing, is anonymity. Anonymity is something brought home to the digital world by the internet. On the one hand, it has created a lot of freedom of expression. On the other hand, it has created a lot of illegal activity. Yeah, I do agree that no one has a recipe. So when you create a right, it is at the same time used and misused, of course. My question to Damir is, well, Damir, you are a practicing attorney, and therefore I think you must know that all those laws, beyond all those laws, piracy laws and blacklist laws and so on and so forth, beyond those laws, there are other enforceable means used by the State Prosecutor's Office, and they direct it not against individuals but against ISPs. And for example, the Russian Drug Enforcement Service has also used their not right but authority to send letters to ISPs to de-delegate a domain name. So how can we fight and how can we protect people from the government's agencies misusing their responsibilities that they don't have? Well, I wish we had a good answer to that. There are high-level acts that regulate dissemination of information in the digital world. There is a European Convention, there is a joint declaration of the freedom of Internet, there is a lot of case law in the European Court of Human Rights. And according to the General Declaration, blacklisting a website is technically the same as closing down a TV network. So closing down a small website is treated in the same way as closing down Channel 1. Of course, there are laws to block certain content on certain resources, and that is in itself okay. If we had real, fair justice procedure to counter, to provide counter arguments, and so on and so forth, that would be no problem. Well, and I'd like to pick up on the comment from the representative of the Russian Federation when he says that the Federation Council considered the law. I have the YouTube video about how long it took the Federation Council to discuss it. It took 30 seconds, I think. Well, it was more than 30 seconds, because it was many, many minutes. You have incomplete information, because I took place in that discussion. So, and I will not point fingers at people, but I can see several people from the Russian Association of Electronic Communications who also discussed that law. And the discussion was very hot and very deliberate. I have a short question to you. When you said that blocking a small website is the same as closing down Channel 1, does that mean that since Channel 1 is a media of mass communication and it has certain responsibilities, so if you say that when you close down a resource, you must treat a website in the same way as Channel 1, then when you open up a resource, you must open it up exactly as Channel 1. Irina, you will have an opportunity to ask your questions further. I will forget it, but okay, okay. I think Alexander has misinformed the public about how the Russian Association of Electronic Communication participated in the consideration of the anti-piracy law. Last autumn, we indeed took part in discussing the amendments package to this law. The anti-piracy law was not discussed with us. Just as Law 139 was adopted just in several days with a mere semblance of a discussion. And when we came to the parliament, they told us, okay, we can discuss certain tactical changes, but not strategic changes, not conceptual changes. And when we wanted to expand the anti-piracy law last fall with the presidential administration, we suggested several amendments to Part 4 of the Civil Code, and we said that only when those amendments to the Civil Code are adopted, we can consider changing the anti-piracy law as well. This is Article 2053, Part 1. But when the so-called Krasheninnikov amendment was discussed in the State Duma, right in 2 days after the first discussion of that amendment, Sergei Zhelezniak from the United Russia introduced another construct which entails double legal liability, which is totally against all the legal principles of the Russian Federation. I will be very brief. Yes, I do think that it should be as easy to open a TV network as to open a website, and should be as difficult to close a website as to close Channel 1. Let sources of information compete. Let people to filter any information that they receive. This will be fair. I represent the network of underground musicians. 5 years ago, one important writer said there should be no editors on the internet. And he said all those editors should be fired. In 5 years, the same internet writer says, we don't know how to write in a proper way anymore. Even though the artistic content is purely artistic, people have to spend money on creating the content, and at least they have to get the money back. I think this is rubbish, because there are some websites now in which you can crowdfund, and the 28 Soldiers movie has already crowdfunded, and people who Okay, the essence of the discussion is that the Pirates Party says it's rubbish, and the Underground Musicians Association says it's rubbish what you're saying. You don't know the technology, I know the technology. Okay, this is the answer. Okay, I will have to stop this discussion, sorry. Some websites can crowdfund a lot of money, some websites cannot crowdfund a lot of money, okay? Madina, can you put some of the illegality? Well, I think we misunderstand the subject of our discussion, because we always talk about intellectual rights and copyright. I can't help having an impression that all people who have gathered here are intellectuals and artists and poets and musicians. I think that we are too narrow in our scope of the rights. Again, we legal people are boring people, and copyright will never die. There is an international treaty that has established copyright, and this is why copyright lives. Copyright is the proof that this or that person owns this or that product. Of course, it is up to the jurisdictions to implement this protection, but again, this is a very, very legal debate. So, I'd like to ask our moderator to set a framework, a broad enough framework for our discussion. If we talk about intellectual rights, I do have a point to share on intellectual rights, but I think we have a much bigger scope. Okay. Let's just imagine that we have all composers and poets and artists here. Okay. I'd like to answer the lady who asked the first question on copyright. She asked how law can affect our behavior. Law is the instrument of the state as an institution, and depending on how a government uses their rights, we can talk about the rule of law. DPRK, Russia, Brazil, China, any other countries, they are different. They have the same rights, but the states, but they use them differently. And having access to the internet and having internet regulated is also a right. It is up to the implementation of the right to say whether I am being suppressed on my internet or I am being given certain rights to do certain things. Duralex, sedlex, as we know. We cannot discuss laws that are already in place. For legal people, there is always the law, and the law must be upheld. However, the big point is that everyone should uphold the law, including the government. In our constitution, we have Article 23. This is a very emotional text, our constitution, I do understand. So, the Russian constitution, Article 15, Item 4 says, international treaties stand above national law. We have signed into 2 pacts on human rights on the one hand, and copyright pacts on the other hand. We must uphold the freedom of expression and so on. However, the government must affect any sphere where public interest and public hazard are in place, like porn, like other things of inappropriate nature. What's important is to identify those things, and it is up to the government to honor these restrictions themselves. The prosecutor's office, FSB, and others. Vladimir Borovitsky, owner and proprietor of one of the oldest websites in Russia. There is another source of lawlessness on the internet. Hosting providers have an opportunity to block websites just because they don't like their owners. What do you, dear panelists, think of it? How to fight our hosters? Well, if we had a law on network neutrality or whatever, it would be easier to fight the hosters, as you've put it. Thank you. All right. We don't have any more questions from the floor. Do we have any more questions from the online? No, because we physically don't have a colleague with a computer here. So, dear panelists, do you have anything to add which is very important and which you did not have any time to state while we were answering questions? Okay, go on. Alexander has said balance or looking for a balance several times. Declaratively, it's very right to say, Alexander, well done. We'd like to see more of that in our lawmaking practices. Because right now, from the standpoint of an internet user, I cannot see any balance being sought by the government these days. Well, I'd like to come back to what Pavel has just said. All participants of this discussion were right from their own point of view, because they have stated their viewpoint. All people said genuinely what their concerns are. I can see that. I can always see when people try to lie. So we have heard several points of view. Some of them are the same, some of them are conflicting. But anyway, I think it was very useful to listen to them, to ask questions, to comment on certain things that have been raised. Because only through such discussions we can come to the right understanding of what the right balancing act is between the interests of users, between the position of the regulators. And I think Alexander was very right to state this notion of justice, of fairness, that rings a lot of bells in the Russian soul. It is the lack of fairness and the lack of justice that we're against. I thank everyone who took part in the panel. I thank everyone who asked questions and answered them. Thanks again.
И хотел бы также сказать, что
And I would also like to point out that some of the materials are available